Good afternoon, everybody. Welcome to London Maritime Arbitration. Costs and time are the thorny issues for users. Who is in control? Thank you all for making this lunch date with us. This session is the first of two seminars hosted by the London Shipping Law Centre as part of the London International Shipping Week. The second seminar, Reality Testing in London Arbitration, Does the System Serve the Needs of Users?, will be at the same time tomorrow, with a slightly different panel. Now, while she modestly appears only as a speaker in part one today, leaving to me the glory of being chair on both occasions, I'm sure that nobody is in any doubt that Aleka Sheppard, the chair of the London Shipping Law Centre, has been the driving force behind both the structuring and organisation of both of these seminars. And we're immensely grateful to her for all the work that she has put in on that. And she is, of course, also our lead speaker in the sense of having the first slot in today's seminar. Now, London arbitration is obviously a huge and very successful business, and we probably all share a degree of pride in our involvement in it. But it has reached that position because those involved in it have worked very hard indeed to make sure the process works over many years, to ensure that arbitration in London is as efficient and effective as it can be, and that problems are identified and solutions found as quickly as possible. The two sessions which we are proposing are looking at two facets of this, if one may say so. The first today is the way that arbitrators control the process. And then tomorrow, we'll look at aspects of the legal structures in place to support arbitration. In relation to each, we're going to look at issues and difficulties and questions that we need to ask ourselves in order to make sure that London arbitration continues to be as good, as successful as it is at the moment. Now, these two sessions have a very interesting distinguishing feature, which some of the more observant of you may have clocked already. They are all women panels on both occasions. And I'd just like to say what a pleasure it has been that when planning for the London Shipping Law Centre's contribution, to find that not only was there so much of interest that we couldn't confine it to one session, but also that there were simply too many talented female speakers available to confine them to one session. Now, before we start, a short word about format. I'm not going to do lengthy introductions of speakers. In the first place, you're going to know them all by reputation anyway. Second place, you can find their biographies on the London Shipping Law Centre website. And thirdly, and very importantly, we have a lot of ground to cover and limited time to do it in. Next point I should just mention is there's no need to take notes. There will be a recording of both seminars, and the papers for the speakers will be published on the website of the London Shipping Law Centre. The format is that each speaker will speak for about 7 minutes. I'm going to be quite tough on them on that, just reminding them. Each one will leave us with some questions to prompt later discussion. Do, however, feed through any questions of your own. Please ask them in the Q&A function. I'll monitor those and we'll work in as many as we can at the end. Moving on, I'm going to hand over to the speakers in a minute. The topics up for discussion are, firstly, Aleka is going to deal with balancing party autonomy with the Tribunal's powers and duties. Then Kathy and Ros are going to do a double act on getting the most from experts throughout the arbitral process. How much control should arbitrators exert over experts? Then Philippa is going to look at foreign law in London arbitrations, how it is proved and who decides. Then Sarra, otherwise known as the other Sarra, or Sarra with 2 R's, will ask the question, do the LMAA terms facilitate the swift and cost-effective resolution of disputes? And Nicola will round off with an industry perspective on Tribunal's proactivity during the process. And after all of those, we will then turn to the Q&A. So I'll hand over now to Aleka. I hope you all very much enjoy what follows. I'm very much looking forward to it myself.
Thank you, Sarah, for your most generous comments about me. Good afternoon or good morning, everybody, wherever you are. It would be nice if I could just see your faces and interact with you, but here we are. We have over 400 participants from 43 countries, but no networking, I'm afraid. Welcome to you all. I set up this event because I thought a debate was needed about the thorny issues of arbitration, about costs and delays. We have a very good arbitration system in London, but we need to ensure from time to time that our users are satisfied. It is often the case, I believe, that we overlook the elephant in the room. So I set the scene with my talk, which is about party autonomy in arbitration, and it is underlying both of our sessions, today and tomorrow. I will focus on how to balance party autonomy with the powers and duties of the tribunal, and I'm mostly concerned with who is in control of the process. This is the central theme of our debate. I do believe that finding the right balance of that control is crucial, and it is upon the tribunal to find it. How to find it, it is a matter for our debate. If a balance is not achieved, the result will be, I'm afraid, an adverse impact upon both arbitration cost and the procedural time. And we do not want that to happen. I will first start with the foundation and scope of the concept, second with its limitations, third, how party autonomy intertwines with arbitral autonomy, and finally, I will set questions for the debate. As you know, party autonomy is simply based on freedom of contract. It is the bedrock of arbitration, and it underpins the arbitral proceedings throughout. It is enshrined in Section 1B of the Arbitration Act, 1996, stating that the parties are free to agree how their disputes are to be resolved, subject to safeguards as necessary in the public interest. It is also enshrined in the New York Convention, 1958. Section 1B is not mandatory, but fundamental. And most importantly, Section 1C of the Act safeguards party autonomy by not allowing court interference. And as you know, most of the provisions of the Act, save for the mandatory sections, do allow party autonomy, and they begin with the magic words subject to the parties' agreement or unless the parties agree otherwise. Next slide, please. Now, what are the limitations of the concept? Party autonomy is subject to public policy considerations and equal treatment of the parties as found in the Lex Arbitri. And next slide, please. Of course, the principles of arbitration, such as fair resolution, impartiality, and adopting suitable procedures to avoid unnecessary delay and expense, to be found in Section 1A and Section 33 of the Act. Next slide, please. Now, how party autonomy sits with arbitral autonomy. As you know, Section 34 provides that the tribunal has the powers to decide all procedural and evidential matters. But tricky Section 34 also provides that the parties have the right to agree any matter. Next slide, please. Here's a potential conflict lurking for tribunals. Tribunals may not accept the variation of parties' agreement if it conflicts, for example, with the principles of arbitration. And what is going to happen then is, should it resign? But another issue again arises if a party's variation is not accepted. Would the tribunal be exposed to an application for serious irregularity? Food for thought here. Next slide, please. However, luckily, the parties' agreement, the parties' right to agree the procedures is subject to Section 40 of the Act, which is an obligation to do all necessary for the proper and expeditious conduct of the arbitral proceedings, and comply without delay with the tribunal's orders and directions. Next slide, please. And of course, it's subject to the LMAA terms. And in the new terms, you find paragraph 15 of the terms, very strict and very proper. So in theory, there is a balance between party autonomy and arbitral autonomy provided by both the Act and the LMAA terms. But I think tribunals should be rigorous in implementing that balance. Next slide, please. All right, questions for the debate. You're in the right slide. No, before that. It's okay, son. Now, first question. If parties delay agreeing on any matter and there is a stalemate, and sometimes about 3-6 months delay, what would you expect or would you want the arbitrators to do? Second question, could party autonomy potentially be an excuse for delaying the process? And third, would an intervention by the tribunal be perceived as trumping party autonomy? Next slide, please. The most important question of all is this. At the end of the day, who do you think is in control of the process? The parties, their solicitors, the insurers, or the tribunal? I do hope we debate these questions. You'll find my answers in my fuller paper. And thank you very much for listening.
Thank you very much, Aleka. Those are some very stimulating questions to get us going. And I think the more detailed individual points are only going to feed into your overarching questions. I think now it's time to hand over to Kathy and Ros for their debate in relation to experts. If I could invite them to unmute and become visible.
Thank you very much. Yes, our format's going to be slightly different from Aleka's, and thank you for your lead up, Aleka, to our presentation. Ros and I are going to do a bit of a double act, as already mentioned. We are going to cover 6 points and propositions that we wish to make about how we believe arbitrators could perhaps control experts and the roles that, in order to get the most out of experts in arbitration. Now, I have to say that there were many more than 6 points that we could have raised, but we are limited by our time, so we're going to limit ourselves to these. Each of those points will be taken either by myself or Ros, and then we'll make some comments about that. And we very much hope that you will have some observations to make about the suggestions that we're making. So the first area that I'd like to address is about the experts' issues. If we could go to the next slide, please. The actual issues that experts are asked to address. Now, this is, in our view, a key way in which arbitrators can control the expert evidence. I know Ros and I have both been involved in cases where experts on the other side go off on frolics of their own. And in a way, if the issues are not defined well enough, it gives them more scope for doing that. Now, that is problematic in a number of ways. Of course, it means often that reports are far too long. They're not very well focused. And it can often mean that as the expert on the other side, you suddenly find that you're having to address in a supplemental report, if you have the opportunity, some points that were never really considered when you did your first report, and that's not good. The other thing that we have both found is that experts don't always address the issues that have been pleaded, and often cases evolve. Issues change as you're going through the case. And it's very important that arbitrators should ensure that if issues do change, that the pleadings must be updated to address that. So our proposition is that arbitrators should encourage experts to be involved at an early stage in defining the expert's issues, right at the time when the order is made for expert evidence. Because without that, if they are too vague, those issues, experts will interpret the issues based on what they understand the case to be, rather than the issues that the arbitrators want us to address specifically. Ros, I don't know if you've got anything further to add to that.
Yeah, thanks, Kathy. I think I obviously agree with the points you've got there, and it's certainly easier as an expert to address the issues if there's been some involvement in putting the pleadings together. It's very much more difficult if those pleadings have already been defined before you come to look at the case.
Indeed. So, Ros, I think you're going to take the next point.
Yeah, if we can have the next slide, please. This is kind of related to the previous point, but this is in relation to a scenario I've come across where an opposing expert has presented an argument in their first report, and then following the experts meeting, completely departed from that argument in their supplementary report. And I think that's potentially related to the previous point about defining the issues clearly. But my sort of point here is that in that instance, perhaps the arbitrator should then allow the first expert to address any of the new issues brought up in that supplementary report in a second supplementary report. Of course, this needs to be adequately controlled to prevent many supplementary reports, but I think this has used quite effectively in the past. Ideally, it would be best if that could be avoided. You know, if experts were very much aware of their duty in terms of only addressing the relevant issues in the supplementary report. And by that, I mean that if an argument is presented in the first report, then it really shouldn't be reinvented in a supplementary report. I don't think that's quite the purpose of the supplementary, if you agree, Kathy.
Yes, I do. And I think that brings us on quite nicely to the next point. So we'll have the next slide, please, which is about joint expert meetings and joint expert memorandums. I have to say, as an expert of many years standing, I think the joint expert meeting and the follow-on memo can be the most useful of all the reports that experts produce for the arbitration and the arbitrators. However, it's only going to be useful if it's well conducted and the memo that's produced at the end of it is one that is written, in my opinion, either at the time of the meeting or signed off very shortly after. The joint expert memo should summarise all the points of agreement and disagreement between the experts to assist the tribunal, and the meeting should be confidential. And I think that is where the arbitrators can exert perhaps a little bit more control to make sure that not only do the experts realise this, but so do the, I'm afraid, instructing solicitors. Now, that in a way can be controlled by the arbitrators saying, we expect the joint expert memo to be signed off on the day of the expert meeting or at the very latest the next day. I'm afraid if you give experts and their instructing solicitors, I'm afraid, too much time, in my experience, what happens is that points that may have been agreed in a joint expert meeting, once they are got hold of by the instructing solicitors on the other side, they try to wheedle their way out of it, and you find that many of the agreements that you thought were being made are not able to be featured in the joint expert memo. So I feel very strongly that this is a way that arbitrators could assist in getting the most out of joint expert meetings. Ros, did you want to add anything to that?
Yeah, only to say that I've had one particular experience where it's taken almost 2 weeks to sign off on the joint expert memo. And, you know, from the starting point of maybe having 2-3 pages of areas of agreement and disagreement, it's come down to simply half a page because the other side have been going back to solicitors. And in the end, it really detracts from the value of the meeting, I think. So I definitely agree. I always try and sign off the minutes on the same day or the very latest the next day.
I agree. And the way I would tend to do it is to have an agenda laid out in the format of the joint expert memo prior to the meeting, in which solicitors can be involved in agreeing what the issues are that we should be discussing. But then that agenda is then used during the meeting to form the format of the memo that can then relatively easily be signed off at the end of the day or, if necessary, the next morning. But I think we do need a ruling from the arbitrators to say it must be signed off, perhaps within 24 hours, say.
Yeah, I think so. And that agenda is the opportunity there for the solicitors to make sure that all of the important areas are covered in the meeting. And I think that's a very sensible way to approach it. I think the issues come when the solicitors start to get involved in the expert memo, which should remain confidential. And that actually, I think, brings us on to the next slide, if we can move along. And again, I think this actually ties into a lot of the points we're raising, but I think a lot of these issues arise when we're working with experts that don't necessarily fully understand what their duty is, first and foremost, to the tribunal. And I think that's potentially somewhere where arbitrators could exercise a little bit of control in reminding experts, but potentially maybe the onus is on the expert to ensure that they have the proper training to understand their role, or perhaps there's even an argument to enforce some kind of mandatory training for experts so that is made very clear. But I think that this particular point would help address many of the issues that we're actually raising here.
Yes, I would agree. Unfortunately, there are, in my experience, a number of people who get involved in expert witness work who may be experts, but they're not necessarily expert witnesses. And it's quite a different role being an expert and being an expert witness. And it's very difficult as an expert witness to have a meeting with an expert who doesn't understand that actually they are not there to argue their client's case. They are there to assist a tribunal, and it does make it extremely difficult. So I think any encouragement arbitrators can do to remind the experts of their duties at every stage in the process. So the next point that I'd like to raise is about encouraging experts to agree methodologies and calculations to assist the tribunal understand quantum. Now, it may well be the case that the two experts don't necessarily agree with the principles behind those calculations. But the last thing that, as far as I can see, arbitrators want to be doing is nickel and diming, looking at quantum. They want to know that if they agree with the principles behind these calculations, that those calculations have been correctly calculated and that both experts agree that. Now, that may seem like a very obvious point to make, but unfortunately, I've come across experts where they totally refuse to agree that the calculations have been correctly carried out because they say we don't agree with the principles, which is not very helpful. What I like to do, and I've seen this increasingly happening, is to provide models to the tribunal such that they can make decisions on some of the issues that affect quantum and then see what impact that has on the quantum figure at the end of it. And I found that particularly helpful. And I would invite arbitrators to encourage experts to do that. So I think on that basis, we would then move on to the last point, because I'm conscious of the time. Unless there was anything, Ros, you particularly wanted to add to that.
No, I think that's fine. Thanks, Kathy. So yeah, very quickly on the last slide, virtual hearings. I know it's causing quite some discussion across the industry. I'm a big fan. I think, number one, from a sustainability point of view, it's hard to justify having hearings in person when it involves lots of people travelling across the country, across the world. I think it's easier to run. I think it encourages the use of electronic documents. And I think it's a more efficient way of giving evidence as well. So virtual hearings definitely get the thumbs up from me. How about you, Kathy?
Yes, they do for me as well. So long as they are well run, so long as the experts are not excluded from being involved in the case, because it's often very important to hear what the witnesses of fact, the evidence that they're giving. So one still needs to be involved. But I'm afraid I don't particularly want to be flying all over the world, using up an awful lot of time and a lot of the client's money if it's not necessary. That's my view of it. So, but I think there does need to be some training given for experts on how to give their evidence virtually. But I would really encourage arbitrators to consider virtual hearings. It gets our thumbs up. So thank you very much for your attention on that. We have got a list of the propositions that we are making, and I think they will be referred to later on in the session. Thank you.
Lovely, thank you very much. And we've got a couple of questions coming on the Q&A for you, but I'm going to work those into the Q&A session. And I think that some of the points that you've raised will be really helpful to feed into Aleka's points about overall control. But now we're going to hear from Philippa Hopkins, who's going to talk about the question of foreign law, which is a subject which is also exercising the court at the moment, how best to deal with that. So over to you, Philippa, if you could manifest, please.
I hope I've now appeared. Thank you very much, Sarra. We've just been discussing expert evidence in London arbitrations in a general way, and now I'm going to say a little about one particular type of expert evidence, or perhaps not expert evidence, which gives rise to particular issues in the context of arbitrations, including maritime arbitrations, and that is foreign law and what to do about it. I come at this from two angles: as a barrister, because I appear as counsel in arbitrations, and I also sit as an arbitrator. Could we go on to the next slide, please, Sam? So the issue arises in the following way. I'm assuming for present purposes that we're dealing with a London arbitration, so an arbitration with a London seat, and in the shipping context, of course, that usually, though not necessarily, means an LMAA arbitration. And if that's the case, the law of the arbitration, or the Cockerill law, as it's sometimes called, is going to be English law. But of course, it doesn't follow that the law applicable to the substance of the dispute is also English law. It might be, it often will be, but it needn't be. Some law other than English law may apply to all or part of the matters in issue. And the question then arises as to how that law is going to be proved. In this presentation, I'm going to refer to it as foreign law, and that seems very London-centric, and I apologise for it, but it's a convenient shorthand. Next slide, please. Now, what happens in court, subject to a point to which I will come, is reasonably clear. And it arises from that peculiar rule of the English law of evidence, which says that foreign law is a question of fact. That goes back to a case called Earl Nelson and Lord Bredport in 1845, and possibly even before that. And because of that proposition, the rule is that foreign law must be proved like any other fact. And therefore, the general rule is that it has to be proved by expert evidence. What happens if you don't have the expert evidence? Well, it's not necessarily the end of the road, because English law also provides that in the absence of evidence as to the relevant foreign law, there's a presumption that the law will be the same as English law. There are limits to that principle, and it doesn't always apply. Sometimes it is necessary to plead out specific provisions of foreign law, for example, in order to get permission to serve your claim form out of the jurisdiction. That's a topic which we don't have time fully to explore today. The current last word is to be found in the Court of Appeal's decision in Four Seasons, Cairo and Brownlee, but that is on its way to the Supreme Court, so watch this space. In any event, there's an air of unreality about all this, because whatever the cases say, foreign law is clearly not a question of fact like any other. And whatever English law chooses forensically to presume, the foreign law is not usually the same as English law. So one starts from a slightly odd position. If you want a fuller exposition on this, have a look at a very good article by David Foxton QC, as he then was, in the Singapore Law Journal from 2017, entitled Foreign Law in Domestic Courts. But of course, a London arbitration isn't a domestic court, so do the same rules apply to an arbitration with a London seat? Do you have to prove foreign law in the same way? And have you got the presumption of sameness if the evidence is not adduced? Next slide, please. There is surprisingly little authority on this. There is a decision of Mr. Justice Thomas, as he then was, called Husman and Alamin from 2000, in which he held that London arbitrators are not obliged to call for expert evidence on foreign law and can apply the presumption if they wish. Does it follow, therefore, that London arbitrations must treat foreign law as fact to be proved, if at all, by expert evidence? Professor Merkin seems to think so in his loose-leaf arbitration law work, but I am not sure he's right. There certainly is another view, which is that in arbitration, the foreign law is a question of fact rule and its attendant presumption don't apply, because they're matters of the English law of evidence, which simply don't apply, at least with their full rigour, in arbitrations. And you get some support for that proposition from Section 34 of the 1996 Act, which is up on the slide. And that, as we can see, gives the tribunal a good deal of flexibility. It's for the tribunal to decide all procedural and evidential matters, subject to the right of the parties to agree. And those include, by subsection 2G, whether and to what extent the tribunal should itself take the initiative in ascertaining the facts and the law. Can we have the next slide, please? For some time now, as many of you will be aware, arbitrations conducted particularly under the ICC rules, but also under the rules of other international arbitration institutions such as the LCIA, have adopted a rather different approach to the question of proof of foreign law. And that approach says that the insistence on foreign law as an issue of fact and the associated presumption are far too parochial and Anglo-centric. If you look at Webster and Buehler's commentary on in the Handbook on ICC Arbitration, you'll see that they say no set practice for proof of law in ICC arbitration, not to be regarded as a question of fact, that has no place in ICC arbitration. And they go on to say most international arbitrators are experienced in various legal systems and therefore are quite flexible as to how the relevant rules of law are addressed. The 2008 International Law Association recommendations, up on your slide, say that in ascertaining the contents of a potentially applicable law or rule, arbitrators may consider and give appropriate weight to any reliable source, including statutes, case law, submissions of the parties' advocates, opinions and cross-examination of experts, scholarly writings, and the like. So, putting to one side the question of whether it is really right that most international arbitrators are experienced in various legal systems, which I slightly doubt and certainly don't lay claim to myself, it does seem clear that arbitrators can and maybe should take a more flexible approach, bearing in mind the international nature of most arbitrations and the provisions of the Act. In the shipping context, the LMAA terms give the tribunal a wide discretion to decide all procedural and evidential matters, though the tribunal, where appropriate, will have regard to any agreement reached between the parties. The LMAA questionnaire attached to the current 2021 LMAA terms doesn't specifically address the question of proof of foreign law, and it might be said that it implicitly assumes that this will be done by way of expert evidence. But that might not be the best way to do it. It's notoriously expensive. Foreign lawyers can charge enormous sums of money, and the cross-examination of experts can take up valuable time in a hearing that could often be better spent. So costs and time are really big factors here. Next slide, please. But if foreign law isn't going to be proved by way of expert evidence in the traditional London way, what are the alternatives? And the answer is that there are plenty. You could have expert evidence, but with so-called hot tubbing. That can result in a proper dialogue between two expert foreign lawyers, which can be a useful way of getting to the heart of the issue and ironing out what appear to be inconsistencies, which are actually more apparent than real. What will often be more appropriate, in my experience, however, is for the foreign law in question to be treated as a matter of submission rather than evidence. And one has to bear in mind that London arbitrators are not bound by rules as to rights of audience, which can make this a bit of an issue in court. And that means that the submissions on the foreign law can, and often most appropriately will, be made by registered foreign lawyers, either orally or in writing. In other cases, it may be that the English lawyers involved are well able to make the submissions with or without assistance from foreign lawyers, especially if the law in issue is part of a common law system that bears close similarities to English law. I spent the end of last term in a lengthy arbitration involving BVI law, British Virgin Islands law, which is almost indistinguishable, truthfully, from English law. And I made the submissions on that law myself. That accorded with the agreement between the parties. Nobody batted an eyelid. Of course, submissions can and usually should include the provision of the legal materials in relation to which the submissions are made, together with translations if the relevant law is not English. Lastly, it is also possible for arbitrators to do their own homework in relation to a foreign law, particularly if they have the appropriate experience and language skills. Next slide, please. Let's move on to some of the problems. All this is very easy to say, but in a particular arbitration, it may be a bit harder in practice to work out the best approach. There'll be questions as to how the right approach is determined, who decides. Of course, the tribunal must have the last word, but the parties' views will matter, and if those views differ, it can be quite tricky to resolve. I think one particularly awkward area can be whether the correct approach is or isn't dictated by the arbitrator's skill sets. Let's suppose, for instance, that there's an issue of French law to be determined in an arbitration. One of the parties is French, and that party has appointed a French lawyer as arbitrator, who undoubtedly has the skills to deal with the French law issues that arise. That's great, but let's suppose that the other two tribunal members are English lawyers, and that the non-appointing party is really not happy with the other party's appointed arbitrator being left effectively to deal with this solo, or at least having an advantage. Problems can also arise with a submissions-only approach if the submissions or materials that are reduced are on the thin side. If the arbitrator is uncomfortable with the level of assistance provided, what is he or she to do? You could rely on the English law presumption, but that might feel inappropriate, it might feel unreal. If the arbitrator goes off and does his or her own research, that really has to be handled with care. And in particular, as with suddenly relying on new domestic authorities, any arbitrator will be very, very well advised to raise with the parties the fruits of his or her research and to invite comment, because otherwise you risk a challenge under Section 68. Last slide, please. So just some suggestions for how to deal with this issue on a day-to-day basis. There's unlikely, I'm afraid, to be a one-size-fits-all answers, but I think these are probably a reasonable guide. First, where the applicable law is a foreign law, how you're going to establish and prove that is something that needs to be considered by the parties and by the tribunal at an early stage and directions given. If you're an arbitrator, that might mean raising the point when you see it coming, even if the parties haven't raised it. Secondly, it's often going to be helpful to identify the issues under the relevant law. Then you can think about the scope of the evidence or submissions that will be required in relation to that foreign law. It's going to focus the mind. Thirdly, the tribunal has to be involved in determining how the foreign law is going to be proved, but as with most things, in my view, should not impose a solution with which the parties are not comfortable. Fourth, submissions type approach likely to be sensible, as I indicated earlier, where the foreign law in question is a common law system, especially if it's English language and very like English law. And as Sarra alluded to earlier, that is an approach which is currently being trialled in some cases in the commercial court. It may be less sensible to do that where the foreign law is less close to English law, particularly where it's really quite alien to the tribunal because of language or because of a very different approach, a code-based approach, for example. And in that case, I think old-fashioned expert evidence may, subject to cost questions, be more appropriate. But that might depend on who's making the submissions and on the skill set of the tribunal. If there are foreign lawyers involved, and if they can make submissions of a kind which will really help the arbitrators, then expert evidence may actually be overkill. And lastly, and as ever, the bottom line, any approach needs to be proportionate and it needs to be cost effective, because otherwise, whatever you do, you could end up with a bill that is vastly out of proportion to the scale of and issues in the case. And those are points which I hope we will be able to discuss later in the session. Sarra and other panelists, thank you very much.
Thank you very much, Philippa. Yes, as you say, there is a considerable overlap with where you get to and what we are currently looking at for the new edition of the guide. So I look forward to discussing that in due course. But now we'll hand over to Sarra to deal with the London Maritime Arbitration LMAA Terms aspects.
Hello, thank you. Well, last year was the LMAA's 60th anniversary. We weren't able to celebrate, I'm afraid, because of the wretched COVID. The LMAA is not an institution, it's an association of individual arbitrators. And testament to the success of the LMAA, there are more maritime disputes referred to in arbitration in London than to any other venue worldwide. Sam, please. Oh, thank you, Sam. If you just look at the stats table I've got there, I'm just going to take the second item. The estimated new appointments last year for the LMAA was over 3,000. The stats show that the aggregation of 5 institutions, some of which are not in the UK, were just over 2,800. I say estimates because it's often quite difficult to rake in all the data, but I would suggest that this proves the LMAA is doing something right. The LMAA members themselves have a wide range of experience and expertise. And I think perhaps the quickest way of summarising what they're capable of doing is that they can resolve a dispute involving anything that floats or is fixed to the seabed. Arbitrations in London are conducted under the Arbitration Act 1996, and this is a quote from the terms themselves, save to the extent varied, modified or supplemented by the terms. And I hope I'll be able to demonstrate throughout this lecture that the LMAA terms are often speedier and simpler than the Act. The LMAA members usually accept arbitration appointments on the LMAA terms, and a big plus, non-members can do so too. Sam, next slide, please. So the big question, do the LMAA terms facilitate the swift and cost-effective resolution of disputes? Well, I say yes, and I hear you say, well, she would say that, wouldn't she? I spoke to a practitioner yesterday and I said, what are you looking for when it comes to your choice of dispute resolution terms? And the answer was nimble, fair, and comprehensive. Well, I hope I'll be able to establish that the LMAA terms are adaptable, user-friendly, and flexible. And I think that ticks all the boxes. And certainly if you read the terms themselves, the objective, which I've set out here, is to obtain the fair resolution of maritime and other disputes by one impartial tribunal without unnecessary delay or expense, a mantra that is repeated throughout the terms themselves. Sam, next screen, please. I probably don't need to summarize for this audience, but in a nutshell, there are 3 sets of terms and procedures which offer a very wide range of choice for the resolution of disputes to a London arbitration. They do provide different procedures, they offer different timetables, and they are suited to disputes of different monetary values. Now, subject to anything the parties might change about that, the terms themselves provide these 3 sets of monetary limits. For the main terms, claims and counterclaims for US dollars 400,000 or more. The intermediate claims procedure, which is for claims between those 2 figures, 100,000 to 400,000. And then the very, very useful small claims procedure for claims and counterclaims, which are $100,000 or less. There are 6 schedules. I know Philippa just mentioned one of them, which is scheduled, the 3rd schedule, which provides a checklist for the parties to identify procedural matters that are outstanding. It also is good at flushing out preliminary issues, which I'll come to in just a sec. And let me just turn to the next screen, please, Sam. Still continuing with flexibility and adaptability. I think I might have mentioned already, but the terms work for any dispute whatsoever. They are subject matter neutral. They can encompass shipping, trade, offshore energy disputes. These are subject matters within the wider use of the word maritime in the heading. And they all cater for any dispute of any complexity. They have a light touch framework, timetables can be followed and adapted, and broad powers are given to a tribunal. They have had 6 revisions in the last 24 years, which I would suggest makes them very nimble. And that enables them to move with the times. So, for example, last year, the LMAA published guidelines for virtual and semi-virtual hearings. Semi-virtual, the LMAA, I think, has been pretty avant-garde in relation to virtual hearings. For years and years now, tribunals have permitted witnesses, both of fact and of expert, to give evidence via video link. And that's already been discussed, but that can give rise to a huge saving, both on time and on cost. There is a new provision in the terms that permits electronic signatures of tribunals when it comes to putting their paw marks on an award. And that was to cater for tribunals who are sitting in different jurisdictions and for whom it was difficult to transport between them the hard copy award. Beware, though, there are some potential enforcement issues with electronic signatures. Next screen, please, Sam. I'm going to give some examples of tools in the toolbox of tribunals and parties, which can lead to a swift and cost-effective resolution. Appointment procedures and constitution of the tribunal, obviously key. And I would suggest that the LMAA offers terms that are procedurally simpler and speedier than the procedures you'll find under the Act. So where, for example, a tribunal is to consist of 2 arbitrators and an umpire, or 3 arbitrators, the party initiating the process who makes their appointment and gives 14 days notice to the other party to appoint theirs in response. If the appointee defaults and fails to appoint within time, the original appointer can appoint their nominated arbitrator as sole, no trip to court necessary. Where a tribunal is to consist of a sole arbitrator, if the parties can't agree, it's simply an email request to the president of the LMAA for the appointment of a sole. Similarly, there's a power to substitute an arbitrator if it were to be the case that an arbitrator has become incapacitated or retired or died. Again, it's a simple email application to the president of the LMAA, simpler than a procedure under the Act. There's a new provision dealing with the reconstitution of a tribunal if there are problems in fixing hearing dates. The guiding principle is that hearing dates should be fixed within a reasonable time, and there's a time scale provided. This is in the 5th schedule. But tribunal members can be asked to retire if they can't offer early hearing dates. And rather crucially, 2 arbitrators are empowered to make awards, decisions, rulings, orders, without always having to appoint a 3rd. Next slide, please, Sam. Further matters that I suggest lead to the swift and cost-effective resolution of disputes by using the terms. There's a power to order concurrency if there are common issues of fact or law, where you have more than 1 or more arbitrations on foot. There is no equivalent power under the Act. And a very interesting schedule, which is the 4th schedule, provides quite a list of matters where both the parties and the tribunal are encouraged to give consideration to the ways in which the process could be made more cost-effective and efficient. I'm just going to highlight one of those matters, and that relates to witness statements. The Commercial Court issued a practice direction last year. Oh, I've just received notice. I'm running out of time. Thank you. This is my last slide. About witness statements. We've all been in hearings where witness statements are beautifully composed, but run to many, many, many more pages than are strictly necessary. And the 4th schedule of the LMAA terms invites the parties to make sure witness statements do not argue the case, use their own words, and are confined to relevant issues of fact. Preliminary meetings are also encouraged, and these days they can be conducted virtually. That would lead on to quite often preliminary issues, and preliminary issues, there are 2 schools of thought. They can be effective and non-effective. Sometimes they can create more work than they intend to resolve, but they are still a valuable tool. And very usefully, there are additional powers given to the tribunal to penalise by way of costs if they consider the parties have conducted themselves unreasonably or inefficiently. And I would just finish off by saying that the LMAA is not, as I've said, an institution, so there are no institutional fees to speak of. There's no oversight of proceedings, there's no delay in appointing an arbitrator, and there is a free choice of arbitrators, unless, of course, you invoke the right to go to the president. Last screen, please. I'm not going to go through this. This is just explaining the uniqueness of the ICP, the intermediate and the small claims procedures. And let me just mention 2 questions for debate. In practice, do tribunals use the tools at their disposal fully or to best effect so as to achieve the swift and cost-effective resolution of disputes? Second point, Do users of the terms consider there are other powers or tools not provided for in the terms which could lead to swifter and more cost-effective resolution of disputes? And that's the end of my talk. Thank you.
Thanks very much, Sarra. And that last slide highlighting the question of do tribunals use the tools at their disposal is a point that's come back to us in relation to witness statements, which resonates, I think, very strongly with what Kathy and Ros were saying, and which we will have to revisit. Are we making the best use of what we have? But first, let's go over to Nicola, who's going to look at the question of the need for tribunal proactivity, which is exactly on point. Thank you, Nicola.
Thank you very much. I will be sharing my screen. As the other members of the panel have been talking about, we've been debating to what extent there is a need for tribunals to be more proactive, perhaps, in the arbitration. I'll be speaking from an FD&D or legal expenses insurer perspective, and very much with the LMAA arbitration in mind. So, London arbitration, as has been mentioned, both by particularly Sarra Cade just now, is very, very much the Arbitration Act with the parties' autonomy in mind. And Section 1 is very broad with the overriding objective. So as long as the arbitration process can obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense, and as long as the procedure is not against public policy, then the parties are very much able to agree their own arbitration agreement. And the Arbitration Act, in fact, allows the parties to decide not only which arbitrators or arbitrators should be appointed and which procedure, but even what date the arbitration proceedings are deemed to be commenced for the Limitation Act purposes. And in fact, the only concrete restriction I've seen in the Arbitration Act as regards the scope of arbitration agreements is that arbitration agreements must be in writing or evidenced in writing. So it's one of the very few contracts under English law that have to be in writing to be binding. However, even having said that, the Arbitration Act allows exchange of emails will count as in writing, or even legal pleadings where one party alleges that an oral arbitration agreement has been agreed and that's not denied by the other party, then that counts as a written arbitration agreement and will be binding under English law. Similarly, the English court has powers in connection with the arbitration and can remove an arbitrator on the application of a party, as has been mentioned, for example, if an arbitrator is no longer capable. But again, even then, the court, when appointing the substitute arbitrator, must have regard to what the parties agreed as regards the qualifications that the arbitrator must have. So very much here, again, the Arbitration Act stresses that the court has powers relating to the arbitrator, but the court is very much the servant of the parties vis-a-vis the autonomy and the process by which the arbitration should be conducted. So that is the autonomy enshrined. And that has very much, as Sarra Kay has mentioned, big advantages. It's flexible, it's, if you like, it's custom fitted to the dispute, and also enables the parties to appoint their arbitrator very quickly and directly themselves. Again, I'm referring to the LMAA. Contrast, for example, with an institutional arbitration, the London Court of International Arbitration, where an arbitration is only deemed commenced when the registrar receives the claimant's written request. And that written request has to be accompanied by the email address, postal address, telephone number of all the parties, a statement of the dispute, summarising dispute, the value of the claim, a description of the arbitration process, the seat of the arbitration, the law of the arbitration, the qualification of the arbitrators, and a fee, which is just under £2,000 compared to the lower fees applicable under the LMAA. And this flexibility, directness, and speed is very much valued by our members and other defence clubs and legal expenses insurers. I certainly would hate to see it go. Having said that, as with most things in life, there is a limit. And there should be a limit. There is a balance to be maintained, as Aleka has said, between the parties' autonomy and the need for a flexible and fair resolution of the dispute. and there should be a limit in that regard to how far a party can derail the process or delay the process, for example, in refusing to disclose documents or delaying in serving their submissions. And so as long as the overriding objective is met, the parties can agree their process. And here, as regards the LMAA, it contains powerful tools for the tribunal to determine the right process and maintain a balance. For example, under Schedule 2, paragraph 9, it provides that the parties are entitled at any stage to ask each other for any documentation they consider relevant. And paragraph 14 says that parties can apply for directions, but only after they've sought to agree the direction. So again, maintaining that balance. And Schedule 3 to the LMAA terms talks in some detail about the LMAA questionnaires, which again is a powerful tool if used properly for the parties to determine what process and procedures should be followed, the number of experts, if any, oral hearing or not, etc. However, London arbitration can be very expensive. You might say that as a defence legal cost insurer, I would say that, wouldn't I? But it's not just me. The LMAA themselves brand themselves as worldwide leaders in commercial maritime dispute resolution. Now, where an arbitration takes so long that the respondent has gone out of business, or where the tribunal and legal costs exceed the claim sum at stake, even where the claim sum is not particularly small, it's above the small claims limit of $100,000, I don't think that's particularly commercial. Equally, I have certainly more than one colleague, certainly one colleague at the club who strongly recommends to our members English High Court over arbitration. I also know that Singapore arbitration is gaining more traction. That's under the SCMA, so the non-managed process similar to the LMAA rather than SEAC. And I have got some suggestions or points for debate that we can talk about to improve the process, or at least to think about in the toolkit. So yes, more active case management. It's great how the LMAA was very quick off the mark in their Schedule 6 of the 2021 terms to set up the system for virtual meetings and virtual hearings. I would very much like to see, even post-COVID, when hopefully we will be able to travel, I would like to see virtual meetings continue. I mean, obviously it's much better time use. It's also very ecological, as Rosa and Kathy have said, rather than everyone flying across the world, and that's absolutely essential. But I think these virtual meetings is not just virtual hearings, but also virtual meetings. For example, after when the tribunal is ready to retire to consider their award, I think it'd be a sensible use of time for the parties in the tribunal to spend, say, 1 to 2 hours just to run through the main arguments or the planks of evidence or any hotly contested issues. Firstly, to make sure that the parties can make sure the tribunal have all those issues on board in hand. And secondly, to the tribunal, where the award is going to be in documents, it would allow the tribunal to be able to ask questions of the parties in case they have any doubts in their mind. Ideally, these hearings or meetings would be without counsel, where it's going to be an award on documents, so as to make sure that the process does remain relatively informal and doesn't become a mini trial where it's actually going to be an award on documents. I'd also like to see a greater use of preliminary issues or more encouragement or flexibility by tribunals. I mean, clearly there are some issues that are promoted as preliminary issues that won't determine anything, in which case it'd be a waste of time to have a preliminary issue. But there are many, both on liability and quantum, as been mentioned earlier. It can be, you can have all sorts of complicated arguments on liability, but in the end of the day, if you can get agreement or at least a preliminary partial award, for example, on some heads of claim as regards dollars, money at stake, that can actually lead to a settlement as opposed to having lots and lots of argument on the merits. So again, it's focusing on where is the most effective use of parties' time to try to get either to an award or to a settlement. And I think preliminary issues can be used more effectively in that way. Again, I would rather have these preliminary meetings to be held by solicitors, especially where the award is going to be on documents. The third, talking about cost as a defence insurer, and talking about breaking issues down into chunks, as it were, into preliminary issues, I would like to see arbitrators being more proactive on cost orders. So during the process, and not just at the final award, but if there are debated procedural issues or a party has lost a preliminary issue, I would like to see the tribunal make a cost order there and then, preferably for that cost order also to be secured pending the partial final award. I think that'd be a lot more effective. There is nothing like a party having to put their hands in their pockets, or dare I say it, defence insurer having to put their hands in their pockets to secure or pay a partial award or a cost order, as to concentrate the mind. And I think that would be a useful way forwards. And the fourth suggestion or debate, issue for debate, is whether there should be an option on the parties in the tribunal's agreement to ask the tribunal to give their informal views on the merits during the process, so before an award. This isn't catered for in the Arbitration Act at all, but on the basis that the Arbitration Act, as I say, is like a servant, it very much has a hands-off approach, a light-to-touch approach, and allows the parties to agree their own process, as long as it's not going to be contrary to public policy or not result in a fair and cost-effective resolution. One option might be, probably at a fairly advanced stage, or after submissions have been exchanged, perhaps after disclosure. So a similar stage as I would normally recommend mediation or a settlement discussions be resurrected. Perhaps that would be also a good time for the parties to have the option to ask the tribunal to give their views. I know that the LMAA is considering at the moment early neutral evaluation, but that would be where a separate arbitrator is asked to give an informal view. I think the LMAA's concern about the parties asking the tribunal themselves to give a view is that the party who ends up on the wrong end of the view might then, and the case goes to award, a party may later suggest that the tribunal prejudged the case. I'm not sure how real a risk that is, or a concern, given that the parties themselves would have asked for that opinion. But I know that's the LMAA is concerned on that account. However, I think if you can actually ask that tribunal, and both parties would have to agree, so perhaps wouldn't be used that much in practice, but I think it's certainly something to debate and something perhaps to put in the toolkit. So those are my 4 suggestions, and I think at the end we're going to be having, or very shortly, a debate about all of our presentations and the questions that we have raised. Thank you very much.
Thank you very much indeed, Nicola. So we're now through with the individual presentations, and we're going to move into the Q&A session. Going right back to our title, which is all about time and costs being thorny issues. I thought we might look at the point that Sarra raised: do tribunals use the tools at their disposal fully or to best effect? Via, one might say, the lightning rod of Catherine and Rosa's views on experts. And we had a couple of things going on there. The first was the question of to what extent should the experts should the tribunal be getting involved in familiarizing experts with what's expected of them. And we had a message from somebody who was a new expert and felt that they had not had sufficient contact with an arbitrator during their appointments. And then we've also got the question of how you devise the issues and how you control the joint expert memorandums. I think there are 3 facets there. How are we using the powers? Does it create more cost than it saves? Anybody like to go? I shall rely on, I shall ask either Rosalind or Kathy to go first, because we are in their section, and then I will probably call on Philippa because I trust her to have an answer.
I'll address this issue about costs. My experience is that if experts are controlled in the ways in which the issues that they should be addressing are limited to those that are of real concern to the arbitrators, And if the joint expert meeting is controlled, I think that can really reduce costs. My experience of a good joint expert memo is it can reduce the issues, certainly to do with quantum and also liability, if it's been well set up.
But how do you do that element of control? Say, for example, in relation to the joint expert meeting, Sean O'Sullivan's left us a question saying, how should the tribunal control this if there are allegations made of party interference or expert intransigence, highlighting that balance to be struck between the tribunal controlling and the content of the discussions remaining without prejudice?
Yes, it is a tricky one. I think there was another point raised by somebody else about the issue being the involvement of the solicitors in the process of the joint expert meeting. And maybe the arbitrators can have some control over that by reminding them that it is a without prejudice process and stress that to them. Ros, I don't know if you have any thoughts on that.
Yeah, I mean, on the initial point about the interaction with the arbitrator, I mean, I agree that you don't necessarily, as an expert, have any interaction until you get to the point of a hearing. That I think any directions obviously come through the instructing solicitors, but maybe it's something as simple as a direction from the arbitrator through the solicitors to the experts that they must sign off the joint expert memo within a particular time frame and without any discussion with instructing solicitors. And then if the case progresses to a hearing, then perhaps it's one of the first questions under cross-examination, just to confirm that is the case. Maybe something like that would just be enough of a reminder for the expert as to how to conduct that meeting. Just a thought.
Philippa, do you see any scope for the tribunal to get involved earlier in terms of setting expectations, assisting in the drafting of the issues, or even limiting the amount of expert evidence?
I do. I think early control is really the key to this, rather than later control. We all have experience of expert evidence, and that's expert evidence of all kinds getting out of hand in court proceedings and in arbitrations. The LMAA rules anticipate a fairly early case management conference or directions hearing, as do the big institutional rules. And it seems to me that that is the time when the tribunal can and should be proactive in relation to the fixing of issues for experts. I say fixing. It's not something that the tribunal needs to do all by itself. It's not something the tribunal should do all by itself. But it's an area where there really can be discussion with the parties' legal representatives. And if that's done well, then actually you can arrive at a set of issues that everyone is reasonably comfortable with. And that will then help the parties and the issues going forward in terms of making sure that the expert evidence is appropriate in the sense that it's going to assist the tribunal, and kept within bounds in the sense that it doesn't result in an explosion of costs. I think for myself that is much easier than the attempting to exercise control at a later stage, and in particular in relation to the expert meeting. And yes, that can be a problem. We all have experience of experts who are not as well behaved as they ought to be, or their lawyers are not as well behaved as they ought to be in the meeting. Ultimately, my view is there is very little you can do about that as a lawyer if you think the other side are behaving badly, or as an arbitrator if you suspect that one or other party is behaving badly, because that meeting is all within the without prejudice protection and you just can't get involved directly. If you do as an arbitrator, it seems to me you potentially compromise your duties and you are at risk of being treated as not having acted fairly under section 33. All that said, there's a bit you can do. You can say, yes, there's got to be a joint memorandum by a particular date. If you can't agree, we'll have a longer non-agreed section than an agreed section. So you can at least do that. And I would say, if you have an expert who is behaving really badly, you might not have direct visibility of that in the experts meeting, but it usually emerges in the cross-examination. Because if that job is done well, then an expert who's being partisan or naughty in some other way will usually be caught out.
Are we looking at a suggestion that you maybe get the experts in attendance at the remote CMC, giving the arbitrators the opportunity, to interact in relation to the issues and the modalities, but also to lay down a marker about how the joint expert meeting is conducted? What do you think, Sarra, maybe?
Very much so. I think the complaint is a valid one, that the relationship between arbitrator and expert is not a very well explored relationship. And there are ways an arbitrator can perhaps make the expert and the instructing solicitors feel a little uncomfortable, because if there has been some inappropriate behaviour, some very well pointed questions which the parties know or suspect might be coming their way, would cause a great deal of professional embarrassment. But I'm very much in favour of early control, and I'm also very much alert to what can go wrong with the joint experts meeting. And I'm seeing far more rigorous directions from tribunals these days, dictating the topics which have been the subject of discussion between the parties and the tribunal, B, how many experts, you'll be surprised how many they try to get away with, C, how soon after the meeting itself the report should be produced, and B, indeed, as Philippa just said, more than one section to the report, clarity, what's been agreed, what's not been agreed, and why. And if I suspected there was some interference, or even not suspect, if I'm told there's been a delay between the meeting and signing off the report, I, for one, would not be bashful at inquiring as to why, and wanting a full explanation from the solicitors.
Does anybody have anything else in relation to the expert side at the moment? Because I'd quite like to, yeah, Aleka, yes.
Yes, I agree with Sarra and Philippa. In my experience, a tribunal has to be careful, because we're touching upon the party autonomy here, and they have to give a warning to the parties that after the questionnaire, the LMAA questionnaire, there have to be a CMC to agree the issues, first the parties, and then if they're ready to involve the experts at that stage. Otherwise, they can have a second CMC once the solicitors decide the issues and discuss them with the tribunal, then involve the experts. Because in fact, I had an experience in arbitration. The experts got out of control with pages and pages we had to read. No, we didn't read them, but so many attachments, waste of time and paper. And those experts, Charles and Nerf, actually, their fees were very high. It was not really contributing to the issues at hand. It was not very helpful to the tribunal. So I'm all in favor with all what Kathy said, and Sarra and Philippa.
Yeah. Thank you. So we've sort of looked at the process from the perspective of one stage in the process. I'd like to maybe move into something else now, look at costs head on, because we've got Nicola's fourth point, which is would a greater use of costs orders during the arbitration process, and not just when issuing a final award, with such orders to be secured pending final award, encourage parties not to run weak arguments and incur unnecessary costs. So we've got that point. And then we've got an interesting point. I'm just waiting to see your faces on this one. Should arbitral tribunals regard as part of their duties of economy and expedition to set costs budgets for the parties by reference to the amount of the claim? So, yes. One of my favourite things in the world, of course, is dealing with costs budgets. What do you think, ladies, in relation to those suggestions on costs orders and costs budgets? Philippa, you had a particularly speaking face there in relation to costs budgets, so I shall ask you to go first.
I always have a speaking face, Sarra, but of course I have experience of costs budgets as the wretched counsel trying to justify my solicitors' fees on this, that, and the other, and indeed sometimes my experts' fees, which can be interesting, or indeed my own, which is worst of all. Yes, well, I think good idea in principle. In practice, Do arbitrators have the skills to be able to do it? I suppose there's no reason why not, but I can certainly see a lot of them struggling with it. I have to say, I think the whole area of costs and arbitration throws up a lot of interesting questions. Cost budgeting would certainly be a new one. But when I sit as arbitrator, I have to confess I find the whole area of the assessment of the parties' costs really very, very difficult. No easy answers is my view, which is no answer at all.
Sarra, you're on mute.
Sorry, rookie error there. Nicola got her hand up first, and she raised the question. So we'll go to her first and then back to Sarra.
Perhaps one simple, fairly neat solution, but I regret I hardly ever see it in practice, is something Sarra Kay mentioned, is the intermediate claims procedure under LMAA terms, whereby, from memory, the costs, each winning party's recoverable costs are capped at 1/3, I think it is, of their claim value. And that's slightly increased if there's a counterclaim they also succeed on. And I think the tribunal's fees are also capped by reference to the amount awarded. So it's quite a helpful thing, quite a helpful discipline, I find, but I very, very rarely come across it. I don't know if that's through lack of knowledge or fear, I'm not sure.
Well, that's a really interesting question, because Hilton Mervis raised this with me in relation to court costs and said, why haven't we got a procedure whereby you have effectively a commercial court procedure with capped costs? Sarra, are people using this procedure with the capped costs? How much business is it getting?
Not very much. Can't answer why not.
Like to play games?
Yes, well, interestingly, there is a question in the third schedule to the terms, which is the checklist. Sorry, it's a questionnaire. And the question is this an appropriate case for the tribunal to cap costs? If so, why? And at what level? And I can tell you 99 times out of 100, the solicitors complete that saying, oh, no, not an appropriate case to cap costs. No. And then there's an earlier question, which is asking for more specific information about the costs incurred to date and the anticipated costs going forward. So there is a focus on costs. The parties are required to focus their attention. And interestingly, this questionnaire has to be signed off by an authorized officer or agent of the underlying client. So the intention is that the client should see the answers to these questions, particularly those costs questions. Well, just on Nicola's first question, should we be making more interim costs orders payable there and then, as opposed to at the end of the case? I think, strictly speaking, the Arbitration Act requires costs to be embodied in an award. So it might not be as simple as dashing off an order by way of email saying pay now, pay now. It might have to be more formalised than that.
Yeah. I mean, in relation to the capped costs, obviously the big thing which bothers people is you don't know how the case is going to develop. And you can say capped costs at the beginning and then something turns up, which then leaves you out of pocket. Is there a way around that? Is the question one that should be asked at a slightly later stage? Is that going to help?
I suppose the LMAA questionnaire, if used properly, would, by that stage, you know what the nature of the dispute is and what evidence you're intending to call. So you should have a fairly clear idea of what your costs are going to be. Perhaps we should make it at the West a term of the solicitor's instructions that the West must sign off or agree every questionnaire. Perhaps that would be a proper control. That's not a thought I had thought of, but that might be a way forward. At least the issue would have to be discussed and it couldn't be glossed over and put a quick no on by solicitors. But
Aleka, you've got something on this. I think you're on mute still.
In my experience, nothing prevents the parties to apply to make applications for cap costs, and then make another one and another. They increase the amount of costs, so they can go on and on if they want. because they can't really get it right, because new issues arise, and it's not easy to. They can put an estimate, and then until further order, they can apply again.
Yes, Philippa.
I think Aleka is absolutely right to say new issues can arise, and that can be an issue with cost capping. Circling back to what we were talking about, I think that can also be an issue with experts and the idea of having experts involved at an early stage, perhaps at the directions hearing. There are plenty of cases where, for quite good reason, the need for expert evidence doesn't emerge until actually quite a late stage, typically quantum, which maybe people should have thought about sooner, but often don't. So, these things do happen. And I suspect that most arbitrators would be inclined to take a slightly more relaxed line than perhaps some commercial court judges, because as arbitrators, we are always conscious that we are only there by the agreement of the parties.
Yeah. And does anybody else have anything further to say on the costs issues at the moment? No. Okay, then I'd quite like to ask about Nicola's point 5, which has raised a question. So she's effectively asked about the informal view of the case during the process where the parties request and the tribunal agrees, a form of early neutral evaluation, perhaps, or medium neutral evaluation. And the question which has been asked is, isn't there a danger in that the party against whom the initial view went will then try its level best to remove the tribunal? So two questions. Do you think it can be a useful tool? And if so, is that a problem, and how do you get around it? Aleka, do you have experience of this sort of early neutral evaluation type approach?
No, I don't think it's very risky. I think I don't have experience of that, but I think it can be risky. And here is not. It's a different process. It's not arbitration. You can have an early mutual evaluation of the case if the parties have agreed. But in the process of arbitration, I think it's risky for the arbitrators to express a view. And now, what if they change their view afterwards? And I wouldn't. I'm cautious about it.
Sarra?
Sorry. I think anything that leads to an early solution to a case must be pursued. And it's akin to evaluative mediators. You can have facilitative mediators and evaluative ones, and it's quite similar. But I think what Nicola's suggesting is informality by the acting tribunal themselves. And I think it's very difficult to have two parts of your head. One that says, this is my informal opinion of the case, and the other half that says, however, I retain independence, impartiality, and neutrality, and I haven't formed a view yet. And I do think it's quite difficult to combine those two parts in the same human being.
Thanks.
Can I respond?
Absolutely.
I'm wondering whether, obviously I'm not an arbitrator, whether is it really two halves of the same brain? I mean, at the end of the day, you're going to be making an award. You have to come to a decision. So what I was really proposing would be that to bring that forward on an informal basis. So it wouldn't be after all the submissions and all the evidence. And perhaps it's easier where there's only a sole arbitrator and there's not two or three of you to discuss. But it's almost what I'm really getting at, I suppose, is to bring that process forward. So once the submissions have been exchanged and there's a fair bit of evidence out there, as I say, when you'd normally go for mediation, you'd feel that the parties would be confident enough that they have enough evidence and information about the case to make an informed decision. Another option would be to ask the tribunal. So it wouldn't be after spending many hours reviewing it in detail, but if you feel able to, you've kept in touch with the submissions, you've looked at the evidence, and you have a broad brush, or maybe you only have a view on one aspect. You could say, well, actually, I think claim head of loss 3 is a complete no-hoper, even if it's just some indication, and that would help the parties again, they would go away and think, well, do we want to carry on with the award, or actually, are we going to be able to overcome that preliminary, that view from the tribunal? And it would then be their risk whether they wish to pursue it or settle it on that basis. Obviously, there are risks. The tribunal, it won't be as full and comprehensive as at the end of the process with a formal award. But if there are cases where at least some parts of the claim, definitely the tribunal has fairly clear view that a party's on a hiding to nothing, or that's a really clear-cut case. It's going to be very hard for the other party to overcome it. I think it'd be useful to have that at an earlier stage rather than wait to a final award.
Okay, Aleka, you've got. Okay, Philippa's had her hand up for ages and ages.
Okay.
I thought it was an old hand, but apparently it's a new hand.
No, it's a new hand.
We'll go to Aleka and Catherine, and then we'll be out of time, I think.
Yeah. I think the big risk is the risk of challenge. In theory, the parties can say, yes, we agree to this, so it's informal, and therefore there's no risk of challenge. In practice, an arbitrator is going to be really worried that he or she will be taken to have closed their mind going forward and will then be susceptible to a Section 68. So I think that's the problem. I think there is a solution, and the solution is go to mediation. You don't have to have the same tribunal expressing a view on something. Go to mediation, and your mediator, if he or she is good, will say, look, you're in a hiding to nothing with this, but that one's all right. And mediation is there precisely to facilitate settlement. Arbitration is, in my view, performing a rather different function.
Completely agree.
Yes, absolutely. Absolutely agree with Philippa. And I was just about to say that I think people are nostalgic of the times of Barclay. Mr. Barclay was an arbitrator who would decide the case over a glass of wine in the restaurant, take the parties together, and they resolve the dispute. These times have gone because we've become more professional and the parties are more demanding. And exactly as Philippa said, and I said in my speech, that's the conflict for the tribunal. It runs the risk of Section 68 application. The parties will say, we didn't tell you to do that. So if there's not an agreement in writing what the parties want, there is a Section 68 application. So the tribunal is very cautious.
Yeah. Catherine.
Yes, only a very small point that whether it's arbitration or mediation, I think there is a danger if experts aren't involved early enough to make sure that the arbitrator or mediator understands perhaps some of the technical issues that experts are there for. The danger is that some heads of claim can be written off without fully understanding them. And I think that's a very important point as well.
Yeah, thank you very much. Right, very, very quickly before we go, tomorrow we're going to be looking at some of the structural changes which we might look at in changes to the arbitration and so forth, and some of these structural issues. As part of that, effectively, there is an opportunity to look at what might be put into any amendments to the Arbitration Act, encouraging tribunal proactiveness, perhaps. If you had a wish list for something that might really be highlighted or emphasized by way of encouraging tribunals to do something more proactively, what would your one thing be that you would want to see emphasized? So is it more use of early neutral evaluation? Is it having earlier informal meetings? What is it? What can we do better? I think I'll ask you in the order that everybody spoke. So Aleka first.
Oh, wow.
Sorry, unfair.
I wasn't focused on that. Actually, perhaps somebody else can go first.
Okay. Catherine.
I'm happy to start off by saying I think control over the joint expert meeting process is the key thing. And whether that's by restricting the length of time that you have to finalise the report, or whether it's stressing that this must be on a without prejudice, non-interventionist basis from the legal team, whatever it is, I think that's absolutely key.
Thank you. Philippa, you're ready to go.
My view is that we can do better, arbitrators can do better by keeping general focus and oversight on the process in individual arbitrations. it's so easy for arbitrators to have an awful lot of arbitrations on their books and not really know what is going on in each. And you then get to a point where something has gone wrong and it's too late to put it right, or if you're going to put it right, it's going to cost somebody a lot of money to do it. So greater attention would be my big point.
Thank you. Aleka?
Yes, I would tell the parties first not to do it. Actually, the arbitration has become too litigious, and the parties do pleadings like if they were in court. I would tell the parties to simplify their pleadings and use a user-friendly language, just proper for the arbitration, not too legalistic. And I would intervene if it was necessary, particularly when a party says, "Oh, wait for client's instructions." Come on, how many months you're going to wait? 3, 4, 6 months. This is a deliberate misuse of party autonomy. And I would intervene and say, come on, are you quiet for so long? What's happening? Are you settling? You have a duty to tell the tribunal. Other tribunals don't want to intervene because they think the parties are settling, don't disturb them. That's not right. I would ask them politely what is happening and have your eye on the ball. Don't let your case mold in your diaries because you're busy writing 50 awards. So you've got to have a diary how to proceed.
Thank you. Sarra?
In a word, stick to the timetable.
Yeah, thank you. And I'm letting, Ros has gone very quiet. I don't know if she wanted to say anything or whether she's ducking in behind Catherine.
Yeah. No, I'm still here. Similar theme to Kathy's, obviously controlling the joint expert meeting, but the next step as well, controlling the contents of the supplementary reports and not allowing that to become another opportunity to present a different argument.
Yeah, thank you. And finally, Nicola, you had a big wish list there from your perspective. What's the biggest ask on there for you?
I think similarly to what Philippa has said, it's easy to say, harder probably in practice, is to keep that oversight. Perhaps arbitrators do need to limit the number of appointments they have at any one time. Obviously, they don't know at the beginning, like we don't know when a demurrage claim arises, whether it's going to be one email, it's finished, or it's going to go to the Supreme Court. You don't know how much time each case will take, but perhaps an idea would be to limit the number of appointments so that real-time management of the case can be oversight by the tribunal.
Well, thank you, everybody, so much. We've reached the end of our slot. In fact, we've overrun by a little bit, but it's been really interesting. We've had some very positive feedback from people, and it's been lovely to see everybody and have such a good chat. Thank you all for attending as well and for sending us such interesting questions. Hope to see everybody again, or virtually see everybody again tomorrow for the second seminar. Thank you.